Morning, everybody. We ready to go?
Good morning, Your Honor. Yes, we're ready at the jail.
Yes, Your Honor.
All right. First matter is Fowler. So the defendant failed to appear. What's the state feels appropriate?
Your Honor, we are going to ask you to leave that bail amount in place, which was set on the warrant at $50,000, along with his original conditions, which included testing for controlled substances. The defendant failed to appear back in June of 2023. We know that even before he failed to appear, he had violations with pretrial services, which included testing positive for various controlled substances, including methamphetamine. He missed some tests, and then he failed to show for an order to show cause set to address those violations. We know when he was arrested this time, he gave a false name to officers of his brother, date of birth and social security number for his brother in order to avoid arrest on this warrant. Unfortunately for him, his brother had a warrant as well. So he was arrested on this offense. So we do believe that $50,000 is appropriate.
All right, defense.
Yes, Your Honor. In speaking with Mr. Fowler, he has lived in the area at 650 Morrill Ave in Reno. He's been there his whole life. He has been working for Arbor Tree Service, trimming trees. He's been there for a couple of years. So we don't believe that he's a flight risk. I do understand he did have a failure to appear. I'm not sure what happened in that case, other than what the state had recited. We did try to call his boss at Arbor Tree Service. We were not able to get a hold of him and his mother as well. But it looks like some of that info is already verified. It looks like his MPRA score is a 5, which is quite low. Looks like he got 2 points for the pending case. Looks like he has a pending case out of Sparks, which I believe is the new arrest that the state had just mentioned, and then they found out he had a warrant in this case. My ask today would just to be either nominal bail or an OR release. And he'll also have to deal with those potential new charges. So as far as nominal bail, I'd ask for probably $3,000 bondable. And with that, I'll submit, Your Honor.
All right, thank you. The state shown by clear and convincing evidence that bail, even outside the defendant's ability to make it, is necessary to ensure the safety of the community and appearance of the defendant. Therefore, will be set as I already said it in this case when I issued the warrant. We'll see the defendant back so it remains as set. December 2nd, 1:30 for an MSC. Thank you.
Okay, thanks.
Ortega and then Arrington.
Your Honor, I was able to speak with Miss Ortega. She is in medical isolation, but we can proceed today.
All right, what does the state feels appropriate?
Your Honor, based on her medium moderate risk assessment score, as well as pretty nominal misdemeanor criminal history, the state's not going to object to releasing her on her own recognizance. And we're not asking for any conditions other than for her to stay away from the Whitney Peak Hotel property.
Any objection?
Sharon, the only thing that I would potentially ask for is maybe some sort of check-ins, mainly because I've had people OR'd with no conditions, and then because they're not checking in, at least they don't know about court dates.
So just I'll stop you there.
Yeah.
Everyone that's going to be released will have a requirement to check in with our court within 1 business day of their release. So anyone released today on Saturday has to show up Monday by 5 p.m. Just so we can make sure we have all the phone numbers and emails and then we text remind. We do multiple text reminders for everybody. We'll text remind their aunt, uncle, anybody they want us to. Through that process. So text reminders are proven to be effective in reducing failure to appear. They're the most effective pretrial thing that we can do. But supervised visits for low and moderate risk are not shown to make any difference. For high risk, supervised visits can show some difference, but you know, since our court doesn't set cases out on felonies for months at a time, we do 3 weeks at the most. You know, their supervision is coming to our court and
Okay.
seeing us rather than having two parents to check in with, somebody else and the court. They just
Yes.
make sure they check in with us. So everyone released will get our text reminders, be required to come in and make sure we have good contact information, answer any questions they have. We also at that time can provide information on how to request to appear by Zoom if they're having transportation issues. Those are
Okay.
really the best practices with regards to reducing failure to appear. And so we'll do that on every case. So we'll see the
Yeah.
defendant
Okay.
by the end of business on the 24th.
Perfect.
Of
Thank
this month. And then at that time was when we'll set the out of custody arraignment also. So they don't have two different dates to try and remember. All right.
Okay, thank you.
No, just check in by the end of the 24th by 5 p.m. No contact with Whitney Peak, obey all laws, make all court appearances are the conditions. Thank you. All right, Arrington and then Cuevas. What does the state feels appropriate on this matter?
Your Honor, the state's not going to object to an OR release on this matter as well. She also scores moderate on the risk assessment. Her only criminal history is a misdemeanor conviction for disturbing the peace out of Sparks Justice Court. We would ask for pretrial supervision along with testing for controlled substances.
All right, defense.
We'll submit on that, Your Honor.
All right. As I've mentioned before, sadly, there is no reliable evidence that pretrial drug testing does anything to reduce recidivism or failure to appear. And in fact, there's a fair amount of evidence that it increases noncompliance, especially on low and moderate individuals. So I can't find that that's a least restrictive means condition in this case. I will release her on her own recognizance, no contact with the location of the crime, check in with our court, man. So listen, this is a really important part. We're at 1 South Sierra Street. I know there's a bunch of courts and it's really confusing. Just think justice, all right? We're the justice court. So check in with us by Monday by 5. Just
Okay.
come down anytime. And then we'll make sure we have good contact information for you and we'll give you your next court date then. Okay?
Okay. Okay.
All right, we'll see you next. Obey all laws, make all court appearances.
Thank you. You still have that fast. RJC.
Cuevas and then Eckinger. All right, what's the state feels appropriate on this matter?
Your Honor, the state is asking for a lower bail. We're asking for $1,000. That's based on his higher risk assessment score of 9, as well as he does show to have 2 convictions for failure to appear this year out of Sparks Municipal Court. Other than those 2 convictions, he has a DUI in 2018, and that is it for his history. However, obviously, most concerning are those compliance issues as well as his higher score.
Right, defense.
Yeah, sure. I'd be asking for an owner cognizance release. It looks like this was just riding a bike without reflectors or lights. He's in search, when he was arrested. And he's lived in this area for 3 or 4 years. If he's released, he can reside at 1795 Opiate Street in Sparks. That's where his mom lives. She's lived there about 5 years. He does do side jobs to support himself. And he does not have a telephone or email. And he didn't have any numbers based on that we could call for references. It's just info that he has given us. So that would, I think, drop his MPRA score down a little bit. And with that, I'll submit, Your Honor.
So what would drop it down?
So I think based on the info that he gave us, that the residence that he could stay with his mom would drop it a little bit. He does do
So drop it 1 there to an 8.
Yeah. And then the side jobs, I don't know how the court would look at that as far as employment goes. I know it's not full-time employment.
And really not verified, right?
Yeah, I mean, he didn't have any phone numbers. That was the problem because he didn't have a
Right.
phone. But yes,
All right, since he's an 8, I will release him on his own recognizance. I was going to set bail. If he's a 9, I will tell you PCS charges, the score high risk, failed to appear, and failed to comply, by far the highest of any other combination that our court sees.
okay.
But since he's a moderate risk, by your investigation, I will, sir, give you one chance. But it's one chance. Next time I was going to set your bail at $10,000. State was asking for $1,000. I don't think you posting $100 was going to do anything to make sure you show up to court or behave. So, you know, you're in, you're out is my belief, and I'll give you this one chance. The first thing you got to do is show up here Monday, the 24th by 5 p.m. and let us know how we're going to get a hold of you if you don't have a phone. How are we going to let you know your court dates? Do you have an email that you check regularly? Do you have a mom that you're going to be living with? I think is what I heard that we can send the text reminders to. But we need to do that. All right. And we'll give you this one shot. And if you don't do it, like I said, you know what's going to happen. Bail laws make a court appearances November 24th at 5 p.m. is your next court date.
Okay.
And let me just, you know, put on the record what I mentioned earlier with regards to the studies. And these are from the National Association of Pretrial Best Practices, the Parole and Probation National Association. After reviewing research tied to pretrial drug testing programs replicated in other jurisdictions, Van Ostrand, who's the main #1 expert on pretrial issues, concluded that none found empirical evidence that could be used to demonstrate that when drug testing is applied to defendants as a condition of pretrial release, it is effective at deterring or reducing pretrial failure, even when a system of sanctions is imposed, because that's one of the current concerns here locally is there's no follow-through. A violation report is done and nothing really is done about it, which obviously violates best practices of behavior modification and something we would never do in our drug courts. We would see somebody very quickly and address it, but a violation report being addressed at the next court date. And so I thought, well, maybe if we do impose a system of sanctions, but what the research is even in jurisdictions that have, there is no proof that it works. And the least restrictive means requires the conditions meet the least restrictive means as well. And so until we're provided evidence to the contrary, that won't be a condition that I'll be ordering. Eckinger is next.
Okay.
And then Nunez.
I was able to speak with I believe it's Ekanger.
Okay.
And he was not feeling well, but he said we can proceed without him today.
All right, Ms. Gonçalves.
Your Honor, state seeking $75,000. That would be with no 10% cash alternative based on the residential burglary charge. The state believes that higher bail is appropriate based on #1, the charges and the facts as outlined in the probable cause declaration. These facts are egregious. The defendant took an opportunity against a vulnerable victim who was in the hospital to not only steal his car, but some of his property, live in his residence. He scores very high on the risk assessment at a 12. You can see he got 2 points for failure to appear. There's no fixed address. We know that he's facing eluding charges in Sparks Justice Court that we saw him on this morning. He has a bail of $20,000 set there. He was convicted earlier this year of possession of drug paraphernalia out of Reno Justice Court. You can look at that case and see that he was OR'd, had pretrial violations, which included admitted to using marijuana and methamphetamine at his orientation. He then missed test during his pretrial and then eventually absconded. Prior to that, he has a conviction for possession of drug paraphernalia in 2024 and a trespassing out of Reno Municipal Court, which has an associated failure to appear as well, and a bench warrant. Convicted of possession of drug paraphernalia in 2023. And then he's got some felony convictions, one in 2021 for possession of a stolen motor vehicle out of Las Vegas, and another one for possession of documents to commit forgery, also out of Las Vegas in 2021. His history dates back to 2008 with some misdemeanor drug charges and a battery. So for all of his criminal history, his continued criminal activity, His other eluding case shows that he flees from police as well. And obviously the facts of this case, state believes the $75,000 with no cash alternative is appropriate. We would ask for conditions of pretrial supervision along with a no contact order with the victim, Mr. Wiles, and a no firearms or weapons clause based on his felon status.
All right, thank you. Defense?
Yes, Your Honor, as the state mentioned, he did have a $20,000 bail imposed in his Sparks Justice Court case just this morning. He cannot afford that bail as set, so any sort of bail is going to be de facto detention, and since he can't afford any bail, I'll just submit, and with that, I'll submit, Your Honor.
All right. The state shown by clear and convincing evidence that bail outside the defendant's ability to make it is necessary to ensure the safety of the community and the appearance of the defendant will be set at $175,000. That is bondable, or by 10%. Again, all the best practices are the 10%. The ABA recommends the 10%. Our administrative order details why that's listed, and that there's no evidence that bail bondsmen do anything to reduce recidivism or increase appearance rates. There will be no contact with the victim. There'll be no firearms. So bail laws make all court appearances. His next court appearance is November 28th at 9 a.m. Thank you. What's that? Fridays? Oh, you're right. So it'd be the following Monday. Yeah. Although I think I need to set it for a 72 for that day. So I'm going to set it for a 72 on the 28th. Because 72 hours, well, let's think. Ms. Costo, I guess 72 hours are only court days, right? 72 judicial days. So we can set it over to Monday. All right, I'll set it over to Monday, December 1st. Thank you. Muniz and then Rainwater.
Muniz waived.
Sir, Mr. Muniz did waive. We are ready to proceed.
All right, Ms. Costo.
Thank you, Your Honor. State seeking $15,000 in bail along with pretrial supervision and testing for controlled substances. We believe that's necessary based on his high risk assessment of 12. Again, this defendant gets 2 points for prior failures to appear. We know that he has a parole and probation hold, and that is related to a burglary of a motor vehicle case. He was literally just placed on probation on October 20th of this year out of our Second Judicial District Court. When I looked at the pendency of that case, the procedural history, he did fail to appear during that case, and a bench warrant had to be issued for his arrest prior to his conviction. Other than that, he's got a misdemeanor conviction for battery out of Reno Justice Court, another felony assault with a deadly weapon in 2021, and then a harassment and a battery conviction in 2020. And I will submit it on that.
I thank you, defense.
I'm just going to submit, Your Honor, based on that information.
All right, thank you. The state shown by clear and convincing evidence bail outside the defendant's ability to make it is necessary to ensure the safety of the community and the appearance of the defendant. There are no least restrictive means available to the court that will reduce the risk that the defendant poses, or I've been provided no evidence of such. So the bail will be $15,000. So bail laws make all court appearances. Next court date, December 1st at 9 a.m. Rainwater. And then after Rainwater, Sanchez.
Your Honor.
Good morning. What does the state feels appropriate on this matter?
Your Honor, state is seeking $10,000 bail. That would be with no 10% cash alternative based on the offense with the category B offense with the victim. She does score highly on the risk assessment at a 10. What we know about this defendant is, besides the violence outlined in the probable cause declaration, she shows to be convicted of a battery on a protected person back in 2023. I suspect that she was given specialty court in that matter, and that it's most likely sealed. It is on her criminal history. However, we can't find it in our system or in the Second Judicial District Court system. So I believe it must have been sealed. Prior to that, she had a battery conviction in 2021, obstructing and resisting. In 2021, she did fail to appear during the pendency of that case. She's got a misdemeanor carrying a concealed weapon conviction out of this court in 2015. a gross misdemeanor conviction for possession of a controlled substance without prescription in 2014, possession of stolen property in 2014 misdemeanor, 2 different drug paraphernalia convictions, resisting in 2012, destruction of property in 2011, and then petty larceny back in 2002. Based on her extensive criminal history, as well as the facts of this case, the state believes that bail and those the conditions would be to be on pretrial supervision along with a no contact order with the Walmart.
All right, thank you, Jess.
Yes, Your Honor. So I'd like to address the battery on a protected person. And speaking with Miss Rainwater, she did do mental health court. That's why this and graduated successfully. So that is why I guess we're not seeing that conviction anymore, as it was, I believe, set aside. So in talking with her, we were able to verify that she works at Taco Bell. She's been working there for 2 weeks. We were able to call her best friend Jessica. Also, she's residing at Safe Camp, which is at the CARES campus. We were told that they're going to hold her pod for a few days. So if she is released, she will have a place to go. So with that, Your Honor, I think the MPRA gets dropped a little bit from the residents, verifying the residents, and it looks like they had already verified the employment. I don't see any points for that. So with that, I just ask for an OR release, allow her to get back to work, allow her to get back to the CARES campus and check in. Otherwise, as she just told me, she's going to lose everything. And with that, I'll submit you.
Well, Ms. Rainwater, I hope you get back into a supportive environment. Sounds like you do well when you have the right resources available to you, the structure and support that you require. But without that, I find by clear and convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant, and that I've not been provided any least restrictive means that would reduce the risk that you pose. So bail will be set at $50,000. That's 50, no contact, no firearms. It will allow you to be released on your own recognizance to district court's mental health court if accepted. So maybe somebody can try and fast track that. That certainly is a best practice that many communities use as a fast track to drug court or mental health court. Until then, next court date's December 1st at 9 a.m. Obey all laws, make all court appearances. Thank you.
Come on down.
Sanchez and then Seabrook. Oh, what's the state feels appropriate?
Your Honor, the state's not going to object to an owner cognizance release, even though the defendant scores very high on a risk assessment. What we know about the defendant is he did just graduate in May of this year from looks like he did adult drug court as a condition of probation, and he was successful and honorably discharged. He does have a very lengthy criminal history other than that, but based on the facts of the charges, the state's not going to object to an owner cognizance release. We are asking for a no contact order with the victim outlined in the probable cause declaration.
All right, owner cognizance, no contact with victim, obey laws, make no court appearances. Sir, you need to be here Monday by 5 p.m. at the Reno Justice Court. We're at 1 South Sierra Street. We're right on the river. Just remember justice. Get to the Reno Justice Court. If you don't, by 5 p.m., a warrant will issue for your arrest. Do you understand?
So yes, sir.
All right, see you then. Thank you.
Here. Step over here.
Oh, by 5 p.m. Seabrook and then Young.
They're open. Once that 5 p.m. they'll get down. So check in, give them your contact.
Thank you, ma'am.
What state feels appropriate? This victim.
Yes, Your Honor. Your Honor, the state is asking for $10,000 bail on Ms. Seabrook. That would be with no 10% cash alternative. We are asking for DAS supervision or pretrial supervision with no use of marijuana or alcohol. We'd ask for testing for both of those substances. We'd also ask for a no firearms or weapons clause and a no contact order with the victim, Mr. Payton, who is on the Zoom this morning. I can tell you that the state believes that that bail and those conditions are appropriate based on the facts of the case. The defendant's 31 years of age. Obviously, herself and Mr. Payton have two very young children, 2 and 5, and that this incident was violent. A deadly weapon was used in the course of this domestic incident. The state certainly believes that she presents as a community safety risk. She does score lower on the risk assessment at 5. She does not have any criminal history convictions. She wasn't able to provide a reference, and she'd been here about one and a half years, and no alternative place to reside other than with Mr. Payton and her family. We were able to speak with Mr. Payton prior to today's hearing. He is asking for that no contact order. He also did provide us information about the defendant's use of marijuana and alcohol, which has become problematic, and he believes plays into the violence that's currently going on. This is not the first incident, but it is the first incident in which she was arrested. So based on the situation and the facts, the community safety risk, the state believes that that bail amount and those conditions are appropriate. I don't know if Mr. Payton wants to make a statement to the court, but I would just ask the court to address him prior to making your ruling.
Right, Beth?
Yes, Your Honor. And speaking with Ms. Seabrook, you can see her MPRA is a score of 5. Most of those points are for employment, residence, and phone. So the residence is where she was living at, was where this alleged incident happened. We were able to also contact the alleged victim. That she was also, he told us that she was going between jobs. She had just quit her job at, I believe it's Junkie Clothing at the Reno Public Market. She was set to start a new job at Thrive Market, which I believe was some sort of warehouse job. She was supposed to start yesterday. So I believe that would also reduce. So I believe her MPRA scores more of a 1 or a 2, possibly. I mean, as the state mentioned, there's no prior criminal history, anything like that. So I'd ask for an owner cognizance release. I understand that the stay away order, the no contact order, that would be fine. And with that, I'll submit, Your Honor.
All right, let's hear from the victim, sir. Just go ahead and unmute yourself. Is there anything you'd like to say? Unmute yourself. You're muted.
Sorry, Your Honor. Yes, I'm Bryce Payton.
All right, is there anything you'd like to say?
Yes, sir. Just wanted to say that sorry. I'm just concerned about Daphne not having the support that she needs.
So you're
the
frozen.
conversation
Maybe
because
turn off your camera. You were going in and out, and then I heard that you're concerned she doesn't have a support system. So just turn off your video, and then I'll be able to hear you probably better.
Okay.
There we go. All right.
Okay.
You're concerned she doesn't have a support system.
Yes, sir. I talked to her mom yesterday, Gail Elliott Seabrook, and she was saying that they have tried to get Daphne mental help previously, and she's refused treatment. And she said that I, as her now husband, am legally responsible for getting her treated and on medication. And I don't understand exactly why she says that, but it just makes my heart sad because what Daphne just needs most is love and support. And yeah, she needs some help with addiction treatment and things, but she needs community support and family support. And I feel like she doesn't have that. I feel like her parents are trying to pawn her off onto me and make her my problem, which is just terrible. I mean, it's so sad, and that's not what I was hoping, obviously I was hoping that her parents would be able to give her love and support and whatever they can do to help out. But I'm just concerned because she, besides the violent tendencies that have happened the past few weeks, she's also had suicidal language to both me and my 5-year-old son. And I'm just concerned for her safety when she is released. I don't want her to hurt herself either, and I want to make sure that she's getting the help that she needs. So those are my main concerns.
Do you think she needs to stay in jail?
She needs to transition. I don't want her to stay in jail. I want her to get addiction treatment and help, but she needs, positive influences and a good community support. She's been talking about church lately, and I think
Which
she
you will
needs
not
that.
let me go, which you won't let me go to church.
Go ahead, sir. Sorry about that.
No worries. Yeah, and I think she needs that kind of support from a community like that as well. Just, I want her to have the things that she needs. And like I said, I'm just concerned if she gets out that she doesn't really have somewhere to go.
Do you want a no contact order?
Yes, sir. I filled out a temporary restraining order and with email communication.
Okay. And the 5-year-old child, is that yours from before the relationship?
No, sir. They are both of our boys are our children. Daphne and I's children.
Do you want her to have no contact with the children?
At this time, yes, I don't feel safe leaving them with her at this time, sir.
All right. So, what you have suggested is very reasonable to expect the justice system to do, which is to quickly assess her and get her the treatment she needs so that she's not a risk to herself or others. And if she get that treatment outside of jail, then we should do that. That system doesn't really exist, unfortunately, for us here in our community. We don't have a lot of services like that available quickly for individuals. If she did need a level of care for her substance use disorder of a residential, it would take a month to get her in there. And she has little to no prior criminal history. And so I'm constitutionally compelled to release her on her own recognizance. I can't find a sufficient basis beyond by clear and convincing evidence to detain her. So if she's released on her own recognizance, there will be a no contact order, and there'll be a separate criminal offense that'll be just as good as that protection order you're seeking, pursuant to NRS 1784845 for the maximum 120 days. She's certainly not allowed to use any drugs or alcohol without a valid prescription, and so that includes cannabis. And there's a fair amount of research that it can lead to situations like we're seeing here with regards to domestic violence. In fact, I have at least 15 peer-reviewed studies that shows that cannabis increases domestic violence. She'll be not allowed to possess any firearms. She'll have to check in with this court Monday by 5 p.m. so that we can make sure we have the means to contact her to make sure she makes her court appearances. Ms. Seabrook, I'll see you Monday. As far as the children, I'm going to allow family court to address that. That's their expertise. I don't know the studies with regards to denying a mother access to their children and what harm that could or could not cause. So you'll have to go through family court with regards to visitation. Young and then Wentz is the next case.
Wait, yeah. I think you're
Young
Oh.
yeah.
and then Wentz. What state feels appropriate?
Your Honor, the state seeking $10,000 bail for this defendant. That's based on his risk assessment score, which was an 8. He was overridden due to his criminal history. He does have a very recent offense in 2021, which is the basis for the charge in this case. Other than that, very serious charge. He also has convictions in 2019 of theft of an elder or a dependent adult out of Redding, California. He's got 2 different convictions, looks like separate convictions for violating a court.
So, Ms. Costa, I apologize for interrupting you. If it's something that the underlying charge I don't have access to, I'd like to know what it is. So we can take this case last if that's what the defense wants to do. Otherwise, I want to know, I'm going to ask the state what the underlying offense is that required registration.
Yeah, I asked to trail it if we're gonna go into that. a
Okay.
little bit more.
All right, thank you. Wentz and then Acosta. All right, what state feels appropriate on this matter?
Your Honor, the state is seeking $25,000 bail for Ms. Wentz. And that would be with no 10% cash alternative. As you can see, obviously the underlying facts of the case are very concerning regarding this 10-year-old child. She scores higher on the risk assessment at a 9. She does have a felony arrest for failure to appear after bail on a felony offense. She was arrested by the Division of Parole and Probation. That was in 2024. She has a arrest for possession of a controlled substance in 2023. Out of our Second Judicial District Court. It appears again in this instance. I don't have access to it, but it looks like it was deferred and adjudicated at some point and sealed because we don't have copies. We don't have it, nor does District Court have it, or do I have access to it through District Court system. In 2022, she was convicted of possession of stolen property. And then she has trespassing convictions in 2021, 2 of them. Another trespassing in 2019. All of those cases revolve around the defendant going to places that are not hers and her having some type of mental health episodes where she believes something's going on, or those are her residences. They were all pled down to trespassings from gross misdemeanor, housebreaking type of offenses. And then she's got a DUI way back in 2003. It's clear the defendant suffers from some significant mental health issues. And possibly drug issues as well. We know she's had the prior drug arrests, but based on that, again, we do believe bail is appropriate. We did speak with the parents of the 10-year-old child. They are asking for a no contact order. They don't reside here in town, I think, as outlined in the probable cause declaration. However, they are still afraid for obviously their son in contact with this individual. And that is what they were asking of the court.
All right, thank you, defense.
Yes, Your Honor, I would be asking for an own recognizance release. And talking with Miss Wentz, she doesn't currently work. She was working at Jim Boys until recently. She has been staying at certain programs throughout Reno. She did give us an address of 1123 East 6th Street, which is Reno Foods, where is a little market that I believe she worked at for some considerable time and also stayed there. She did tell us she stays at the Cares campus and the Mill Street campus. She is currently trying to get into our place. She does not have a phone number. We did try to call her daughter Sonia. We were unable to reach her. I think with that, Your Honor, I would just ask for an own recognizance release. And with that, I'll submit.
All right, the state's shown by clear and convincing evidence that bail is necessary to ensure the safety of the community. The appearance of the defendant will be set at $50,000, posted by bond or 10% cash. No contact, separate criminal offense pursuant to NRS 178-4845 for the maximum of 120 days for the minor. Obey all laws, make a court appearance December 1st at 9 a.m. is the defendant's next court date. We'll see you back then. Costa and then Young. Do you have a copy of the criminal complaint?
Yes, Your Honor, I did give him the copy of the criminal complaint. His name is spelled correctly on line 7. He is aware of the contents, so we'll waive formal reading today.
All right, does he want a speedy prelim or an MSC?
Yes, Your Honor, he would like a speedy prelim.
All right. Set that for, let me just double check, I think December 5th, but let me double check real quick. See how that's looking? It looks good. December 5th at 1:30 for a preliminary examination. What department is this tracking to? Do we know?
Department 6, Your Honor.
6?
Yes.
All right. So we will do a MSC for Tuesday, just to confirm the speedy prelim. All right. Let's see. I set the prelim for the 5th, right? Actually, we'll do the MSC on Tuesday the 2nd. So that's 3 to give the attorneys some time to try and negotiate the case. That's 3 days before the prelim. Also, I was looking though, Ms. Costello, and these offenses, felony firearms, have a greater than 90% chance of going to district court. Of all our felonies, they are the highest probability of going, as we were trying to determine what cases go there. So good chances are going to go. Either way, we'll set it for Friday afternoon, the 5th, and an MSC for Tuesday, the 2nd, both at 1:30. We'll see you then, sir. Thank you so much. Oh, bail. We need to talk about bail. This is a warrant. What does the state feels appropriate?
Your Honor, we're asking you to keep Judge Sullivan's bail amount that she placed on the it originally was an arrest warrant, or it is an arrest warrant, I'm sorry. She placed $25,000 bondable only with no 10% cash alternative. She also put conditions of no firearms. We believe that's appropriate. As you can see, the defendant scores high on a risk assessment at a 12. His history is a little bit confusing because we know that in 2020 he was arrested for attempted battery or attempted assault with a deadly weapon. That was out of the 3rd Judicial District Court. He originally got probation on that case. Then he's convicted that same year of attempted battery with a deadly weapon, causing substantial bodily harm. That occurs out of our court. I believe he gets sent to prison on that case. He then gets revoked on that probation for the attempted assault with a deadly weapon. It looks like in 2024. And he ends up going to prison on that case. The pretrial services paperwork says, or his criminal history reads, that he just got released from parole. He came straight from prison to here, appearing in front of you on this arrest warrant. So he's now on parole, which started on the 21st, and then that goes through till May of next year on that Lyon County case. In addition to those very serious felony offenses, he has a misdemeanor conviction for DUI back in 2019 with multiple post-sentence violations. He's also got a conviction for an affray in 2017 down from a domestic battery out of Fernley. And then finally, a misdemeanor conviction for using a false ID in 2017. So the defendant has recent violent history. This offense, which is from December of 2023, comes after those attempted assault with a deadly weapon and attempted battery causing substantial with a deadly weapon. But obviously he gets sent to prison after this offense is committed. It originally came in, I think, and we know we issued it based on some further evidence. We got that evidence, then we stopped the arrest warrant, and that's sort of the little bit convoluted procedural history. But either way, based on his criminal history, the state believes that that bail is appropriate.
All right, thank you, defense.
Senator, as the state pointed out, this was filed, it looks like in July of 2024. Mr. Acosta was in prison. He did come here from NNCC based on the warrant, so he's clearly been paroled. So there's obviously some sort of plan in place to ensure his compliance with parole and probation. My ask today would just to be an OR release, and then he can, deal with this case on the outside. He will be on parole, so he will have supervision already, but you can order whatever conditions you would find appropriate. With that, I'll submit.
All right, thank you. I'm confident that Judge Sullivan did not know of all the facts and circumstances that the state has just provided when she set the bail. Because we don't get that. We don't get the criminal history. We don't know all those facts and circumstances. We set the facts of the case. And you know, maybe someday when the state seeks a arrest warrant in the future on individuals like this, they can provide that information and a request for bail to be set on that original amount. I know I suggested that to Mr. Hahn when he was in charge of the criminal division. It'd be nice to know what an appropriate bail amount is at that time. Given all the additional facts and circumstances, I find by clear and convincing evidence that bail outside the defendant's ability to make it is necessary to ensure the safety of the community and the appearance of the defendant have not been provided any least restrictive means that would reduce that risk. So the bail will be $100,000. Now, again, the ABA and the best practices are, as detailed in my administrative order, that it is postable by 10%. No firearms, no bail laws, make a court appearance. It's December 2nd from 9 a.m. to the defendant's next court date. We'll see that, sir.
Thanks.
Young is the next man.
Yeah, like. Oh, actually, the second,
Fifth at 1:30.
but the seconds is NSC.
Both of them are at 1:30.
Yeah, okay.
The second and the fifth.
Okay, thank you.
You're welcome. All right, what's that underlying prior on Mr. Young's case?
Your Honor, his conviction is for annoying or molesting a child under the age of 18 out of Shasta County, California.
All right, and that was 2022, you said?
2021.
2021. And then he received, what did he receive? What was did you see the disposition in there?
It was a misdemeanor.
Was he on, because I know California has sometimes, you know, probation on misdemeanors for 2 years. Just wondering if he was on probation or is there any further information?
Hold on one moment. And he's right. It was a misdemeanor. He was arrested for lewd or lascivious acts with a child. He pled to annoying or molesting a victim under 18. He had a suspended sentence as 12 months probation. It was the sentence on that case, and that was in 2021.
All right, thank you. Go ahead with your argument.
In addition to that, again, he had 2 different misdemeanor convictions for theft of an elder or dependent person. Those are all of his criminal history is out of California. And then he's got those 2 different convictions for violating court orders and domestic violence cases. Also, those were out of Redding, California. And then he's got a misdemeanor conviction for domestic battery back in 2004. Based on that criminal history and based on the override by pretrial services and his failure to comply with sex offender registration so soon after his conviction, state believes he does pose a danger to our community and would ask for the bail amount, which was $10,000.
All right, that's.
Yeah, sure. And speaking with Mr. Young, he's lived in this area for 5 years. If he is released, he would stay at the CARES campus. He's been staying there the past 6 months or so. He does have a case manager at CARES campus, Cecilia. We did try to call them. I believe they opened at 9 a.m. We were just able to leave a voicemail there to try and verify that info. So I would ask for an OR release that he stay at the CARES campus, that he have check-ins with testing based on the drugs that were found.
There was no drugs
thank you.
on me.
I know. On the car.
Sorry.
State shown by clear convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant. I've said it before, I'll mention it again with regards to the override. Dr. Austin validated the NPRA. He looked at the instances when Washoe County Pretrial Services overrode individuals and found that they appropriately did so, meaning if they overrode somebody to hire to reoffender failed to appear, they behaved that way. We know individuals that are in the higher degree offender failed to appear category or in the 50th percentile of being successful. And so unless there's a significant way to reduce that risk, in many of those cases, bail is appropriate.
I'll check.
What's interesting is the research is the best practices they're actually supposed to override down also. And I've never seen that, an override down, but pretrial services are they're allowed to override. It should only be in about 10% of the cases, but they should be overriding down as well. And I only see overrides up for what that's worth. But either way, in this case, I've made my finding $10,000 bail or bail laws make a court appearances December 1st at 9 a.m. is the defendant's next court date. We'll see him then. Is there anybody else up at the jail?
No, I think that's it, Your Honor.